What you are about to hear is not speculation, and it is not commentary built on headlines. It is a careful reconstruction of events that unfolded earlier today based on official court documents and verified timelines. Understanding what just happened is essential because the implications extend far beyond a single individual, a single company, or even a single election cycle. Earlier today, the United States Supreme Court issued a unanimous decision that resulted in the dissolution of the Trump Organization. All 9 justices agreed on the outcome. While much of the public conversation has focused on the name involved, the financial consequences, or the political optics, those angles miss the deeper significance of the ruling itself. This decision is not just about one organization. It establishes a legal framework that could reshape how corporate accountability is enforced in the United States, particularly when misconduct is found to be systematic rather than incidental. Most media outlets quickly summarized the ruling with short headlines. Anchors debated what dissolution means in practical terms. Analysts discussed real estate values, loan exposure, and asset liquidation. But those surface-level discussions overlook the most consequential part of the ruling, the legal reasoning embedded deep within the opinion. Rather than relying on summaries or commentary, the full text of the decision must be examined. When read in its entirety, it becomes clear that the court was not narrowly addressing one case. It was articulating a standard. The court concluded that the Trump Organization engaged in long-term patterns of misrepresentation across multiple contexts. Asset values were presented differently depending on the audience. Financial institutions received one set of numbers. Tax authorities received another. Insurers were given figures that did not align with either. According to the ruling, this pattern occurred repeatedly over several years. Crucially, the court determined that these were not isolated mistakes or accounting discrepancies. The behavior was described as structural, meaning it was embedded in how the organization operated. Because the misconduct was integral to the organization's internal processes, the court ruled that lesser penalties would not be sufficient. As a result, the justices concluded that dissolution was the only appropriate remedy. Financial markets reacted quickly. Major indexes declined during early trading hours, particularly in sectors connected to commercial real estate. Investment vehicles with exposure to properties associated with the Trump Organization experienced sharp drops. This reaction, while notable, was predictable. What was not predictable, and what has received far less attention, is the broader legal standard the court articulated in its reasoning. In one key section of the ruling, the court stated that any corporate entity demonstrating persistent and systematic misrepresentation, when such behavior is embedded within its organizational structure, may be subject to dissolution if other enforcement mechanisms have proven ineffective. Importantly, the court emphasized that this standard applies regardless of the political identity or public profile of those involved. That language matters. Legal experts note that this phrasing significantly broadens the scope of potential enforcement. It does not limit application to a specific industry, size of organization, or level of public visibility. Instead, it establishes a principle. When misconduct becomes a defining operational feature, extreme remedies are legally justified. Several constitutional law scholars have already pointed out that this type of language has rarely appeared in Supreme Court opinions. It represents a clear signal that the court is drawing a firm boundary around corporate conduct. The timing of the ruling has also raised questions. In the days leading up to the decision, multiple legal actions involving related figures and entities showed signs of movement. Requests for expedited hearings were filed. Previously quiet investigations appeared to resume activity. While no direct coordination has been proven, the alignment of these developments is notable. Political reactions followed predictable lines. Public statements from allies framed the ruling as overreach. Critics framed it as accountability. But behind the scenes, a more complex dynamic appears to be unfolding. According to multiple reports from within political circles, there is growing concern about the broader electoral implications. Internal polling suggests that independent voters increasingly view ongoing legal controversies as a liability. In closely contested states, even small shifts in perception can have significant consequences. This has created a strategic dilemma. Defending the ruling risks alienating core supporters. Rejecting it risks losing moderates. For some lawmakers, there may be no clear path that avoids political cost. At the same time, activity in financial markets suggests that institutional investors are preparing for prolonged legal uncertainty. While some assets declined, others rose, particularly in sectors associated with legal services and regulatory compliance. This pattern indicates that markets are pricing an extended litigation rather than a quick resolution. Notably, several large investment firms reduced exposure to legally sensitive real estate holdings weeks before the ruling became public. While this does not prove foreknowledge, the timing has prompted questions about risk assessment and information flow at the highest levels of finance. Another aspect of the ruling that deserves attention is what the court did not include. Despite the unanimous decision, none of the justices issued separate concurring opinions. In cases involving complex constitutional issues, it is common for justices to explain their reasoning individually, even when they agree on the outcome. In this instance, the absence of separate opinions suggests a deliberate choice. Legal analysts interpret this silence as an effort to present the decision as institutional rather than personal, grounded strictly in legal standards rather than ideological interpretation. The implications of that choice are significant. It suggests the court was focused on preserving its authority and minimizing perceptions of internal division, especially given the politically sensitive nature of the case. Looking ahead, several scenarios are possible. If the liquidation process proceeds without resistance, the situation may remain within the bounds of normal legal enforcement, albeit on a large scale. If compliance is delayed or challenged, additional legal conflicts could emerge. Over the next several days, filings, responses, and procedural decisions will clarify which path is taken. Each step will further define how this precedent is applied and whether it becomes a reference point for future enforcement actions. What is clear is that this ruling extends beyond a single organization. It introduces a framework that could be used to examine other entities where misconduct is alleged to be systemic. That possibility alone is enough to explain the level of attention and concern now visible across political and financial sectors. This is not a moment defined by rhetoric or speculation. It is a moment defined by legal text, institutional authority, and the long-term consequences of precedent. Understanding that distinction is essential for understanding what comes next. As the legal process moves forward, the focus is shifting from the initial shock of the ruling to its long-term structural consequences. What matters now is not public reaction, but institutional response. Courts, regulators, political parties, and financial systems are all adjusting in real time. One of the most overlooked aspects of this ruling is how deliberately it was timed. Supreme Court decisions are not released randomly. The court controls its calendar, its docket, and the order in which opinions are announced. This decision arrived at a moment when multiple legal timelines were converging. Federal prosecutors are facing upcoming filing deadlines. State-level investigations are nearing critical procedural stages. Civil enforcement actions are transitioning into execution phases. By issuing this ruling now, the court effectively removed uncertainty surrounding one major legal question: whether systemic corporate misconduct can justify the most severe remedies available under civil law. That clarity changes everything. For prosecutors, it simplifies strategy. Arguments that once depended on disputed interpretations now rest on established precedent. For defense teams, the margin for delay narrows significantly. And for institutions observing from the sidelines, the message is unmistakable. Structural misconduct carries structural consequences. Political institutions are also recalibrating. Campaign strategists are not debating legal theory. They are evaluating risk. When a candidate or political figure becomes legally entangled at this scale, the impact extends beyond courtrooms and into electoral math. Internal assessments indicate that legal instability alters voter behavior, particularly among independents and undecided blocs. These voters tend to prioritize predictability and institutional stability. Prolonged legal conflict undermines both. This places political allies in a difficult position. Public loyalty may satisfy core supporters, but it does little to reassure broader coalitions. Silence, on the other hand, creates its own problems. Every response carries cost, and those costs are now being calculated with unusual urgency. Behind closed doors, contingency planning is underway. These discussions are not ideological, they are logistical. They involve timelines, messaging thresholds, and exit scenarios. When political organizations begin planning for multiple outcomes simultaneously, it signals that confidence has already been shaken. Meanwhile, financial institutions are reacting with a different kind of discipline. Capital moves faster than politics. Investors do not wait for speeches or press conferences, they adjust exposure based on risk probability. Following the ruling, several market signals became increasingly clear. Volatility rose not because of surprise, but because of duration. Markets are preparing for extended legal proceedings, enforcement actions, and appeals. That expectation favors sectors tied to compliance, legal infrastructure, and regulatory navigation. It disfavors sectors exposed to reputational uncertainty. Another critical dimension of this moment lies in enforcement. Court rulings carry authority, but enforcement requires cooperation across agencies. When an order involves asset liquidation, contract termination, and organizational dissolution, execution becomes complex. Courts rely on compliance first. If compliance is immediate, the process remains procedural. If compliance is contested, the situation escalates. Each additional layer of resistance introduces new legal questions and new institutional pressure points. Historically, institutions are tested not by rulings themselves, but by responses to those rulings. Legal historians note that moments of systemic stress often reveal the true strength of governance structures. When enforcement proceeds smoothly, it reinforces legitimacy. When it stalls, credibility erodes. That is why attention is now shifting from what the court said to what happens next. Another subtle but significant aspect of this ruling is its potential reach. The legal standard articulated by the court is not limited to commercial real estate or privately held corporations. Its logic can extend to any entity where misrepresentation is proven to be systemic and operationally embedded. That includes political organizations, fundraising entities, and complex financial structures. This does not mean widespread enforcement is inevitable. It does mean scrutiny is now justified where it was previously contested. For organizations operating near ethical boundaries, the margin for ambiguity has narrowed. This has triggered a quiet but noticeable shift in internal audits, compliance reviews, and governance restructuring across multiple sectors. Institutions are not waiting for investigations. They are proactively insulating themselves from exposure. That behavior alone illustrates the ruling's broader impact. The absence of dissent in the decision continues to draw attention from legal scholars. Unanimity in high-stakes cases is rare, especially when political implications are involved. Even more unusual is the absence of individual concurrences. This suggests that the justices prioritized institutional unity over interpretive expression. In practical terms, it limits avenues for future challenge. Without fragmented reasoning, there is less opportunity to exploit interpretive differences in subsequent cases. It also signals that the court views this issue as settled law, not an evolving debate. Looking forward, the next phase will unfold across several timelines. In the immediate term, procedural filings and compliance actions will determine whether enforcement proceeds smoothly. In the medium term, related investigations may accelerate, now armed with reinforced precedent. In the long term, this ruling will shape how courts evaluate organizational misconduct for years to come. What is unfolding is not a single legal battle. It is a recalibration of boundaries between power, accountability, and institutional integrity. Moments like this are rarely obvious while they are happening. They become clear only in hindsight, when patterns emerge and consequences accumulate. But certain signals are unmistakable. Legal standards have shifted. Institutional tolerance has narrowed, and the cost of systemic misconduct has increased. This is not about personalities or narratives, it is about frameworks. The rules governing corporate and political behavior have been clarified, and those rules now carry sharper consequences. What happens next will depend less on rhetoric and more on compliance, enforcement, and institutional resilience. The system is being tested, not by chaos, but by procedure, and that distinction matters.